Manever I say ma PENDREAM TV. PENDREAM TV there, osia dem yopo.
Abusia for say eye MPP for say eye ruling na Supreme Court ma ye efa the 4 vacant seats aba e parliament no eno ano no omawie omo na be majority in parliament nti no sese ba bia wu ama omo ne ho ade abusia eye ntro ani eye ntro ka kire omo say eye ntro abusia NDC for plans omafa ni agenda ni adwunempo a ewo mu chin eno na me pese yekobo video yi e kire na hu said Sam Jata George honorable Sam Jata George oye ningu pram empesu aso mashebedwani said you sika ye ni plans a o ma planning e dia fa judgment a buy no me pese ye court na ye kohwe eba sisi abusiafo aha PENDREAM TV. Make sure also subscribe to the channel, like the video, na share to other platforms more so in your video. What dream chrebia o share na we to comment section no ase. So mobekaya a friend is saying honorable Afenyo Markins o chiremu a ni nti omo no omo mpene enkotena minority seat no so say spiritual omo kotena so na chese spiritual omo lose elections no edinti na omo kotena so yen hwe se NDC voice so ebe pene se yebekwa kotena minority seat no so a na omo so lose election and ye na omo jejiriji yen kotie nkomo no mra.
What is the import of this particular ruling to the extent that political parties now, if per what that's Visitors of why is saying is anything to go by, have been rendered powerless in taking any disciplinary measure against any of your party MPs who were sponsored by the parties on the ticket of the party to get into parliament if they take a decision to contest as independent candidates in subsequent elections.
Again to our viewers and to my co-panelists. When you read the dissenting judgments of Lovelace GSC and Amadou Tanko GSC, you see the pains that these members of the bench are in, because it's obvious to them and obvious to anybody who applies common sense to the ruling to realize that there is a battle of wits between common sense and the ruling that has been given by the majority grouping in this case. Like, there is a complete battle between common sense and logic and their ruling. The majority decision in this case. And you see, because even the judges led by the Chief Justice in the majority realize the lack of common sense and the lack of legal logic in their ruling, they only deal with relief one, that's a sort. They are silent on relief 2, 3, and 4. And so this judgment is hollow and empty and of no consequence to the Parliament of Ghana. I mean, the Speaker should not waste his time with this. He should just put it in the dustbin. It has absolutely no value. And so when I see Afenyo and his men running around that they've secured a victory, you ask yourself, a victory in what? You went to court asking the courts to make a declaration and issue a directive or an order on Mr. Speaker, on the pronouncements Mr. Speaker has made. Despite, for want of a better phrase, unreasoned judgment and logic espoused in the majority judgment, they realize that that will be pushing the boundaries too far. And so they stay away from making any ruling on Mr. Speaker. So there is no ruling on Mr. Speaker. If you read the whole thing, there is no directive to Mr. Speaker. Absolutely no directive to Mr. Speaker.
Yes, because they say they can't do that. So if you want declaration of the seats, go to the High Court, page 14.
Is that not why I say common sense has eluded the judges who have made this particular... When you read this judgment, you see that common sense has completely eluded our judgment. You know why? And that's the point Justice Amadou Tanko makes. That look, the Constitution is clear. Read Article 99(1). And every article of the Constitution has a subheading. It says determination of membership. You said the Constitution is supreme. Article 99(1) says the High Court shall have jurisdiction to hear and determine any question whether a person has been validly elected as a member of parliament or the seat of a member has become vacant. I mean, common sense, there's a difference between High Court and Supreme Court. If the Chief Justice was not seeking to pander to the wishes of political powers in the executive,
allow that for the High Court to do so and pronounce on it. From your own, why didn't the Speaker? Why didn't the Speaker?
Make your point. Make your point.
You see, the Speaker has not made any determination on vacancy. Because again, don't forget. That when you go to 97(1), it doesn't impose a responsibility on the Speaker. It imposes a responsibility on the member of parliament to vacate their seat. It does not say may, it says shall. A member of parliament shall vacate his seat in parliament. And goes on in G. For F, it says if he resigns, okay, that's G. If he leaves the party of which he was a member at the time of his election to parliament to join another party or seek to remain in parliament as an independent member. And I'm glad Eko, in his submission, established the fact that Article 97 is dealing with the current parliament and not the future parliament. So it clearly means that Eko's explanation here today renders useless and completely illogical the arguments that have been made by Afenyo Makin and Jogate in court. I mean, and this is why you must realize that understanding of the law is not necessarily your longevity at the bar. We must establish that because Eko is a much younger lawyer, but he's been able to read through and understand that 97 is not talking about future parliaments. 90. You stated it here.
You supported
I have not said anything different from what you said. And Eko is spot on it. Is bull's eyes. Eko is bull's eye when he says 97 is talking about this parliament. The speaker's pronouncements have absolutely no consequence on the 9th parliament. They only have consequence on the 8th parliament. When it says you will vacate your seat, it is not talking about you have no seat. None of us has a seat in the 9th parliament. Eko, you are sitting in a stronghold, so it's assumed that you will win, but you don't have a seat yet. Have you been sworn in? Do you have a seat in the 9th parliament? No, I don't have a seat in the 9th parliament yet. I'm hopeful to God that my people will return me to parliament and that God will grant me life to swear in on the 6th of January. Until that is done, I don't have a seat. So you cannot be telling me that the vacation of seat is relative to the next parliament. And that's why I'm saying that if the Lord Justices had applied or even just logical common sense to what the Constitution says, we will not have this needless constitutional drama. Now, if it then means...
So the common sense talk about is after in the ruling, not on the persons, in the ruling.
It's about their ruling.
Okay.
I mean, I'm saying that there is no common sense in the ruling. When you subject this ruling to common sense, you see that they're having a fight. There's a fight between common sense and the logic espoused in the ruling. I'm not referring to the persons of the Lord Justices. Absolutely not. I'm referring to their reasoned judgment. And I'm saying that I do not see reason in their judgment. Good. Now, let's make the point that if a member of parliament, Eneko, you were voted for to this 8th parliament, not because you are handsome or not because you are tall, contested on the ticket of the NPP. If you had contested on the ticket of the NDC in Old Tafo, you would not be sitting in parliament. Let's call a spade a spade. Your people entered into a social contract with you. You are sitting in parliament not because you have freedom of association. You are sitting in parliament because there was an election. Your people old enough to be your grandfather and grandmother queued to vote for you, just like me. They voted on the basis of the representation I made and you made to them. I made a representation to the people of Ningo Pram Pram that I'm contesting on the ticket of the NDC. You made a representation to the people of Old Tafo that you are standing on the ticket of the NDC. It is that social contract we entered into with our constituent that gave us a seat in parliament. We sit in parliament not for ourselves, but in trust for the people we represent. Now, a decision of you or me or any other one of the 275 to alter that social contract means that you no longer have legitimacy.
Alter in terms of current or future?
Current.
But their intention is...
Wait. No. The question of vacation of seat is not about future, it's about current. The speaker's ruling. Listen, Echo. The speaker's pronouncements do not say that Cynthia Mamle Morrison, Kojo Asante, Andre Siama, and Peter Kwachiaka cannot sit in the 9th parliament. The speaker has no such power because he cannot even be vacating something that does not exist. Do you understand me? The 9th parliament does not exist. The only thing he can enforce vacation of, which 97 of the framers of the constitution intended in 97-1 is the current parliament. Today, wait, Echo.
So why did the Speaker of Parliament assume that there is a...
No, the High Court would only do that when there is a dispute. Listen, this is what
there was a dispute.
So if there was a dispute, why didn't you go to the High Court? Why did you go to the Supreme Court?
Because it also borders on interpretation.
Absolutely not. So
it borders on interpretation.
No. When you read the rules of practice, Echo, the rules of practice, and you see, this is why, Echo, please. This is why people say the Chief Justice, and I'm singling out the Chief Justice, because she is the one who empanels, and she is the one who has led us into this constitutional crisis. She spoke about a constitutional crisis. The Chief Justice is becoming detrimental to our democracy.
Why is that?
Listen, the Chief Justice herself is aware that the Supreme Court on several occasions has refused to hear matters where their original jurisdiction has been invoked when the Constitution is clear. Article 33 of the Constitution and Article 99(1) of the Constitution are clear when it has to do with fundamental human rights. Your first point, of course, should be the High Court. When it has to do with determination of membership or a vacancy, it's the High Court.
It has exceptions.
There's no exception
There
here.
are exceptions.
There's no exception here.
No.
There's a point.
We will go to Article 130. Wait. Alfred, hold on. Article 131 says, subject to the jurisdiction of the High Court, the enforcement of the fundamental human rights and freedoms as provided in Article 33, the Supreme Court shall have exclusive original jurisdiction in matters relating to the enforcement or interpretation of this Constitution. Good. All matters arising as to whether an enactment was made in excess of the powers conferred on Parliament or any other authority. Now, where have wait. No, listen. Article 131 has existed.
Why is his argument?
That because of Article 131, it's an exemption to Article 33. Listen.
Of course, it's an exemption to Article 33.
Listen. In that instance, what it would then mean is that the Supreme Court would then have jurisdiction on every matter.
That's not true.
Because every matter that goes before any court in this land are based on the Constitution or an error of the Constitution. So then it means that every lawyer would then wake up and say that, look, I don't want to go to the High Court. I don't want to go to a court of appeal. I'm invoking the original jurisdiction because this is a fundamental human rights issue. And so I'm going. That borders on absurdity. And that is what our Supreme Court, led by the Chief Justice, some members of the Supreme Court, are lending themselves to such legal absurdity. Because you see, it is legally absurd that our Supreme Court, our Chief Justice, would allow herself to be used in such a manner to bring the Supreme Court to a place where the Supreme Court is standing in direct conflict when it comes to original jurisdiction on matters of fundamental human rights and a determination of membership or vacancy of same that is explicitly spelled out in the Constitution as the prerogative of the High Court. In fact, it goes ahead to say that when there is an issue that borders on interpretation in the High Court, the case in the High Court will be stayed for that interpretation to go to the Supreme Court and come back to the High Court. Yes. Now, what you are seeing is a Supreme Court under the current Chief Justice that is overly overstepping its boundaries. First and foremost, seeking to get into the matters of Parliament, which is a closed book. And I expect, Mr. Speaker,
it has not happened now. I mean, that is. I
expect, Mr. Speaker, I am expecting, Mr. Speaker, I'm expecting, Mr. Speaker.
Read Article 125.
No,
it has nullified that closed book argument.
I have respect. I have respect for our viewers. I'm not going to be doing this with ego. No.
Senior, I agree. Senior, let me see to you. It's fine. Go ahead.
Good. Thank you. Listen, the Chief Justice is overstepping her powers and is bordering on abuse of her powers under Article 296. She's being arbitrary and capricious and malicious in the use of her powers, usurping the powers of her own lower courts, the High Courts, and then seeking to tell Parliament what to do. And that's why I have said that if a Chief Justice thinks she's so vested with so much power, she should come and sit in Parliament, convene Parliament, and go ahead and conduct government business for them. But you see, the Chief Justice must know, like the Speaker said, that we do not respect the supremacy of the Supreme Court. We respect the supremacy of the Constitution. The Supreme Court has no supremacy over the Parliament of Ghana. And you see, it pains me that members of Parliament are complicit in this rape of the powers of Parliament, because today it serves their partisan parochial whims and caprices. And that members of Parliament, Echo, you know, and Afenumaki knows, that look, to challenge a ruling or directive of Mr. Speaker, our standing orders give you a fantastic opportunity to come under a substantive motion. So today, you are telling me that every time any member is unhappy with a ruling of the Speaker,
which ruling
we will go away from our standing orders and run to our godmother sitting at the Supreme Court to give a ruling and say, look, then the Supreme Court should be ready to cite all members of Parliament on the majority NDC side for contempt. You must be ready to cite 136 of us for contempt and cite Mr. Speaker for contempt. But let me serve notice already that I have summoned the head of the Association of Magistrates and Judges. What's his name again? He's one of the new judges that was approved recently by
you summoned him for what?
I've cited him for contempt of Parliament because he held a press conference and told a blatant lie. Unbecoming that a member of Parliament, because he didn't mention my name, he says a member of Parliament led a mob to the Supreme Court seeking to invade the Supreme Court and heap invectives. He must come before Parliament, our Privileges Committee, and establish for us which member of Parliament carried out such action. Because I led a group of clergymen to the Supreme Court to demand action of the Chief Justice, who has been sleeping on the LGBTQ case. The Chief Justice has become a cog in the wheel of justice. The same Chief Justice, a matter involving Parliament and the usurpation of the powers of Parliament under Article 106. The Chief Justice has now become a cog in the wheel of justice, standing against the wheels of justice grinding, and is playing ball to help the president evade service. I mean, look, it is a shame, it's an aberration, and like Justice Amadou Tanko stated, I hope that in the nearest future, a properly constituted Supreme Court would vacate this ruling, which is a stain on Ghana's legal jurisprudence. Look, any judge worth his salt or any law student anywhere in the world who picks this majority ruling would have a good laugh at the Supreme Court of Ghana. And it's a shame that such a court that has such distinguished personality, and that's the point, in 1 minute, that's the point, that's 10 seconds, that's the point Martin was making, that you've got fantastic lawyers, Justice Poman, Justice Bafoboni, Yoni Kolendi. There's a reason why such reasoned and detailed and seasoned legal minds were kept away from this.
So,
they will not. They will not.
Look,
for any consideration,
I'm
bring themselves down to this.
What is the
unfortunate
ruling? What is the status?
Sam says, hold on. When Sam says that the Supreme Court was silent on all other reliefs apart from one.
Yes,
that is where
we will get back into that.
That is why I wanted you to comment.
Let me just also indicate
that the Supreme Court realized that it would strip them naked.
Your microphones are off. And let me just also remind you that we are live as well on 3FM 92.7, also on TV3 Ghana on Facebook. Now, what's the status of Cynthia Morris and Kojo Asante now?
She's campaigning against.
No. Wait. Are they still MPP MPs?
I want to comment on one or two things that our brother said.
If you're not answering that, if you're not, I asked you a specific question. No. If you're not answering that, let me acknowledge the presence of no. If you're not answering that specific question that I asked you, then I'm going to move on. Because it was a follow-up question to an issue that you Sam George raised.
Because I don't even know the question. I don't even know the question. I'm just saying.
The question is, Cynthia and Kojo, are they MPP candidates?
What I'm just saying.
Are they not campaigning against your candidate?
I'm suggesting to you.
That's what? That they are not campaigning against your candidate?
No. Sam George, what is their status now?
They have declared an intention.
Are they MPP?
No, it's not an intention. They have declared their intention.
They have declared an intention.
No, you shouldn't allow Vincent to do this. Vincent, you are a lawyer.
The 9th Parliament.
No, you are talking about menstrual. Have they done the actus? Has the act not been for something to be found? No, the act and the intention has been actualized by them filing nomination and by them campaigning.
I just needed an answer. You have just given the verdict.
No, they have not shown an intention.
Gentlemen,
they have acted
your
out.
Microphones are off. Your microphones are off. Thank you.
Abusafo enti enkomo no ene yakofa ede abramo ewo TV3 eye the key point jumadie no so abusafo mo ankasa mate ensam no sede esiko ye eye Sam George ena ede ensam no nyina abetudwa a wo kiremu a eye EC Supreme Court ane omo ensam omo keka ne de omo ne omo de befe so pa anya ade a omo judge omo sa say Supreme Court antumi anka amma speaker no any form of directive there it is still asam no e da so ekonkon ba bia ekonkon na ti abuja for NDC for omo ni abere MPP for so say omo de minority na nya ade omo kwakotena ho ne nya ade omo kwakotena ho chena ade ntira omo no omo susu say according to some spiritual deben no so omo kotena eye the friend saying no omo ko ye minority na spiritual nature so omo lose election no we ye koye ana ye bae omanya ye the constitution ene ye adwuma na minority leader we ya afenyo markings ka bibi ntia wo se emra ye di ye adwuma na ye mfa nto ho na ye nkɔhwɛ spiritual because wo kɔtena offense we so a na chese nkunya ketwa na wakɔtena so can you imagine abusuafo can you imagine na makos fa echiri akohu chief justice ama na organize panel bi dia akɔtena honom akɔyɛ dia eni kwan sɛ enkomo ye we ye koye ana ye bae abusuafo abra yi na yi nim sɛ akwan a ɛyɛ chief justice enam so no ɛyɛ wrong a total crap a eni kwan sɛ ye soso so kra na san sɛ wo Supreme Court nim sɛ case a etesa no a high court na according to constitution omudi unless there is something that has to do with an interpretation of the law be na of the provision no be na omode abre wo Supreme Court na wa hwehwem e de amon na Supreme Court enim sɛ edikan ekɔ eye high court one ma they may not be able to control justices or more honum na eno su kusi a na say NDC for we din kunimiti no and yendi kan emma the interpretation no ento ho ansana sabio yakoka eye offense main issue no krampo aba oh eye offense oh high court we say for eno ena abi wiwie baby ayadu enti NDC for the almost say kiane kin baby omutim no mutim ho there is no way almost so jai majority no akota minority they will still be there et ye na ye sabi ye de ensagu ye damri famu na ye hwe de ebesi ebetie de ebesi ti de hia no say ode wa fidie na abrebia no beba PENDREAM TV aba abehwe sese na eko na yatumi abom obusan for high PENDREAM so be like video and share to other platforms so na bon modern say obe subscribe at the amain PENDREAM TV say edam yopo
Dedi kama mamena PENDREAM TV ase na so far so good say open online portal e wo Ghana nipa share nipa follow nipa comment here to my best of knowledge without any biases PENDREAM TV